I haven't looked at the questions. There's not that many questions, are there?
No, there's one which I haven't got a clue about, so I'll be handing over to you guys. Taking a while tonight. Here we go. Nearly. It's kind of frozen at about 80%, which is interesting. Hmm. Okay, guys. YouTube's been slightly weird in that it's saying we're not live, but we clearly are, because I can see us. Well, if anyone's out there, welcome to tonight's thing. I don't know what's. Just give a minute with YouTube. It's just deciding what on earth it's going to do. I might have to do. Okay, well, let's assume it's working. Oh yeah, people are saying, "Oh, cool." Well, hey, you right, Helen? You right, Nor? So yeah, usual stuff, guys. Yeah, don't share personal data in the chat. Don't ask questions in the first person. Just put them in the third person or ask them as what if questions, even better. This ain't legal advice, as always. We're going to do our best here to be useful, but obviously we're limited in terms of what we know and what we get from the questioners. So yeah, just bear that all in mind. And as always, we've got 5 questions that came in through the week. So we'll start with the anonymized ones of those, and then we'll get into the live chat, and then we'll come back to the ones which are not anonymized at the end. So again, I'm just trying to prioritize those people who, yeah, keep it all anonymous. And I guess just worth saying as well, as always, if you want to give it a like and a share or whatever, or a subscribe, then feel free to. If you subscribe and you click the bell button thing, you'll get notifications of other videos. Um, yeah, so yeah, you can put questions in there, but just ask the question like a what if question. So rather than saying, I've been told to wait until the bailiff comes, just say, what if someone was told to wait until the bailiff comes? So you're not there before putting your personal data onto the internet, which is one of the reasons why I do it. I'm a big stickler for data protection because it's part of human rights, but it also gets your brain to work differently, which I'm not going to bore you about the reasons for that. But yeah, it gets you to separate out all the stress from the actual legal issue. So yeah, that's the way it works. So if you ask a question in the first person, I will politely delete it and ask you to rephrase it. But yeah, welcome. Nice to have you here. So, question. Oh yeah, bit of gossip this week. Quite a lot actually in the news, isn't there? So we've got the ending of the Vagrancy Act, which everyone's going bananas about. I've never met anyone who's been prosecuted under the Vagrancy Act. I've been working in the sector for 20 years, but it does seem that it's much more of a London thing than it is in a lot of the kind of leafy places like I live in Bedford. So yeah, and but I'm shame Shanna's not here tonight because I think she knows more than I do about it. But basically, it is being replaced by something on the sly. There are still going to be powers that the police have to kind of take action against people who are being a nuisance or seen as being a nuisance, like daring to sleep rough somewhere, for example. So I don't know that it's all amazing. But yeah, as a point Shannon makes quite a lot of the time is that when councils tell you to go and rough sleep in order to get verified, I guess it's one less bit of law that's been broken there, but it's still illegal to do that. So yeah, um, and I guess there's this big kind of spending bill going on, 39 billion for social housing, which over a 10-year period or something, I can't remember how many years, which will make a dent. You know, that's good. Probably not enough in my opinion, but yeah, way better than it's been. So if they actually get delivered, then we're in a much better position. Do you guys have any interesting goss or anything's come up in casework or anything like that? Anything that people might want to find interesting?
I've got a couple of things. The one I was just mentioning before we came on live, there's actually a webinar on it. I don't know if that you've got the link, but the Welsh government are talking about abolishing priority need and intentional homelessness as concepts used in assessing homelessness, which is a fantastic step forward, and makes me wonder why we have tolerated the existence of these Because the ridiculous thing is that everyone knows that if you've got children and you're intentionally homeless, you're not really expected to sleep on the street. But the way that the law could be presented would make you think, yeah, you are actually, you're intentionally homeless. We don't have to help you, even though you've got a baby that's 3 weeks old, which is terrible because the existence of this concept causes a lot of harm. Whereas if they actually said intentional homeless doesn't really matter in that case, then you think, well, actually, it's a very dodgy piece of legislation that's just designed to scare people and mislead them. So I'm hoping it'll, where Wales leads, England will follow.
Yeah, I mean, I'm skeptical that England will follow. I think it comes. I mean, yeah, it comes down to they realise that if everyone was in priority, or, if everyone effectively becomes in priority need, then there's not enough resources to fix everything. Which in one sense that's not a valid argument, but that's I think what they'll say. I mean, even now, so it's an interesting question around Welsh law around priority need already. So as far as I know, they use the same vulnerability cases that we do in England. So they still talk about HOTAC and PANI O2 and stuff. But in their code of guidance, it's much better. It gives additional categories of priority needs, and it also says things like people sleeping rough are likely to be in priority need, which is helpful. I mean, that, as far as I can tell, there's no reason to say that's not the case in England, but it's nice that they actually said it because you can then quote it. So yeah, interestingly, and I'm also interested by what. Surely you have to have some kind of concept of intentional homelessness just to stop people who have a perfectly decent home but want to move, which is why I think it was originally in there. So let's say you just wanted to move kind of districts or something like that, then there has to be something which would kind of prioritize people who haven't had just manufactured their homelessness. But I don't know. Interested to
There's a
see
way
what
to
comes of
deal
that.
with it, isn't there?
Yeah,
Because the danger, I mean, sort of people at the sort of other end of the spectrum of the argument here will say, well, obviously you'll just have people handing in their keys every time the ashtray's full and coming down to council, and we won't have any way of stopping them. But I'm sure you can come up with something and say, well, you've got a right, but presumably it will be held under more scrutiny next time.
yeah.
Um,
So you've got that concept of knowingly worsened your housing conditions in part six, which isn't the same as intentional homelessness, but that might be a bit more like it. Um, yeah, cool. Yeah, that's interesting. Anything else, guys, before we get into it? If not, we'll go for it. So yeah, cool. Right. So as I say, we're going to start with the questions that have come in through the week. Again, this is just me trying to nudge people into asking questions in advance. It gives us more time to have a look at it, and it also just means that you haven't got a character limit. So obviously on the live chat, you've got like a text message size character limit. So you've got to spread it over multiple questions, multiple messages. So it can get a little bit interesting to try and follow. So yeah, that's again why I'm doing it that way. Just get it up. So question one is this one here. Let me zoom in a little bit and just get the top of the screen as well. So number one, does the prevention duty end when the section 21 ends? So good question. We need to duck and dive in a little bit of the code of guidance. So in fact, let's go back to that. So the homelessness code of guidance is the rule book for councils. And it basically, yeah, it kind of covers a lot of detail about this sort of stuff, and it's not written in legalese, which is quite nice. So you can Google it, it's free. And basically in chapter 14, let me just share this screen so you can see what I'm looking at. In chapter 14, you've got loads of stuff about the relief and prevention duties, and it's basically asking, so this section here, circumstances in which both prevention and relief duties may end. So firstly, someone gets housed, basically, so they're no longer homeless, or they're no longer threatened with homelessness. That would bring the relief and prevention duties to an end. You've then got the housing authority has complied with the prevention and relief duty and 56 days has passed. I'm still a little bit confused about this in terms of how this actually works in the real world, but that seems to say to me that councils can just end things after 56 days, whereas elsewhere it talks about that it's good practice for councils to continue under review in some circumstances if the person's still homeless, for example. So interesting one. I'm not going to go into the detail of it here because the answer to your question starts here really. So an applicant who was owed the prevention duty, as in they were threatened with homelessness, has become homeless. So that's kind of question we're talking about here. So someone's been served with a valid Section 21 notice. When they're within 56 days of that notice expiring, they are threatened with homelessness, and therefore the prevention duty should start very, very soon after making the application. There are some other reasons why the prevention and relief duty would end, but that's kind of starts us. But then we come back to our favourite question, which is about at what point do you become homeless in the eviction process, in the Section 21 process. We have questions about this every week because it's such a common thing, and we have all obviously have the kind of default advice that councils give unlawfully, which is that you need to wait until the bailiffs come, which is not true in most cases. But this question of whether you're threatened with homelessness or whether you are actually homeless is what kind of is going to dictate when the prevention duty ends and the relief duty starts. And just to make the point that homelessness, legally, homelessness is much broader than just people without a roof. So as we can see here, in most cases, effectively, you're likely to be homeless. This wording here, unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of the Section 21 notice. That is code, and it's not secret code. It's well within the guidance everywhere. Basically, it talks about it all the time. That is code to say that you are likely going to be homeless when the Section 21 expires. And then the closer, with the further and further down the eviction process you go, the more and more likely it is, or the less and less unlikely it is. I'm just doing double negatives here. I'm going to confuse myself. So let's look at 6.36. It's highly unlikely to be reasonable for the applicant to continue to occupy beyond the date in which the court has ordered them to leave the property and give possession to the landlord. So again, and then it's like basically says families with children, as in people who are in priority need, is effectively what this is saying. Basically should ensure that homeless families are not evicted through enforcement of an order of possession as a result of a failure by the authority to make suitable accommodation available to them. So at the end of the process, it's basically definitely not okay to do that. But there's this kind of sliding scale. That's where the confusion comes, and it is genuinely confusing. It should be pretty more clear than this. But in effect, if the Section 21 is valid and the landlord's not going to change their mind and there would be no defence to the possession order, then that's probably what we're talking about here. So that's when essentially when the prevention duty should transfer into the relief duty. And that with it, if you're in priority need or if you might be in priority need, that would be also when interim accommodation should be offered to you. You have a right to stay until the bailiff comes. You have a right to do that. But a lot of people don't want to do that because they don't want to incur court costs and they want to have some kind of idea of what's going to happen next. So we just circle back to the actual question to make sure I've actually answered it or try to answer it. Does the prevention duty end when the Section 21 ends? In most cases, yes, but there's that kind of but in it, unfortunately, which means that they would again if the landlord is looking like they might change their mind with a bit of bribery from the council, then potentially the situation would stay under prevention duty until the council are satisfied the person is actually homeless. So I apologise that that's not a very clear answer, but that's not my fault. That's just the way the law's been made, unfortunately. So, Karis or Will, do you want to add anything to the answer to that question there? Does that well vaguely make sense?
No,
I appreciate it's like silly,
I
isn't it,
think
really?
we
But
covered it.
yeah. Okay, cool. Question 2. Another nice short one. Got like the short ones. What if the rent arrears are not your fault, but the DWP's? And I'm assuming we're talking about here in relation to intentional homelessness. And it just so happens that if we go back to the Homelessness Code of Guidance, if we go to 9 point something, 9.17, something like that. Yeah, so this is talking about whether the action that left you homeless or led to you becoming homeless should be considered deliberate and therefore potentially mean that you're intentionally homeless. Even then, it's not automatic. There's still some other conditions that have to be met. But if we look at this first one here, so generally an act of omission should not be considered deliberate where, for example, the act of omission was non-payment of rent or mortgage costs which arose from financial difficulties which would be beyond the applicant's control or the result of housing benefit or universal credit delays. So I assume that's what the question is asking about there, is that basically there's been some kind of delay or suspension of the claim or something, which might then get sorted out down the line. If you get evicted because you can't pay the rent because that's happening, then you should not be considered to be intentionally homeless. So yeah, again, any additions from you guys?
Yeah, I've got an addition to this one, if that's okay. And it overlaps with the last question and the prevention duty. And this is one of the things I think that the prevention duty was intended to deal with, but is nevertheless overlooked. So let's say the person who's got the rent arrears, or who had the rent arrears and lost their home, if they rewind to the point where they first had problems with rent arrears and the landlord was getting heavy with them and maybe served a notice of seeking possession, or wrote to them saying we're going to evict you, at that point you go to the council, I think. Well, I mean, obviously you try and sort it yourself, but if you go to the council and say, look, I'm at risk of losing my home because the landlord's threatening me with possession action due to these rent arrears, and it's the DWP's fault. Can you help me? Now, I think that would trigger a relief duty, sorry, a prevention duty, and the council could then contact the DWP and try and find out what's going on, and also contact the landlord. And I've had it in cases, believe it or not, where not only will the council sort of recognise that the DWP is the problem, but they will actually offer to pay off the rent arrears which have arisen. And I had a case where they paid off thousands of pounds of rent arrears. And the beauty, so that's a fantastic opportunity to get the problem solved, which makes sense. But the other thing is, of course, that once you've done that, you've got to get out of jail card in terms of intentional homelessness, because you can say not only was it, say the council say to you, sorry, we don't know what you're on about, which is a real risk with this type of thing. Say they do that, you've then got another reason why you're not intentionally homeless, because the council didn't help you and you tried to get help, but if they had helped you, and so it wasn't a deliberate act that led to it. It was in many ways the failure of the two bureaucracies. So that's I think a useful thing to remember is get help from the council in avoiding homelessness, and they can't really. It's much more difficult for them to accuse you of being intentionally homeless.
Cool. That's helpful. Thanks, Will. Anything else at all? We're all good for the next one. So third question is one I don't have the foggiest idea about, but I'm hoping Will and Karis do. So if a defence was not offered in a fast-track eviction county court process, the landlord's original Section 21 county court case was withdrawn on 8th of, I think it's that 24th of August due to my defence. Can the possession order decision be appealed if sufficient evidence that was not available before the defence expiry come to light? For example, the assured shorthold tenancy agreement referred to in case had been replaced in 2017, but was not referred to in the case. Does that make sense to you guys? Because as I say, this is I don't have any experience in this at all, so I don't know if that is coherent or not.
Not yet. I'm just trying to get my head around it.
So whilst you're getting your head around it, let me go to the next one, which I
Yeah,
probably
yeah,
do have.
we'll come
In
back to
fact,
that. Yeah.
let me get to the live stream because the next ones I've just realised that wasn't anonymised. So we'll get onto the thing. Hey, you right, Shadnet? Nice to have you here, mate. So where's our question here? Here we go. Okay. So it's actually another question on a similar theme, but I don't know the answer to this either. But if landlady submitted a possession order into the court and has made many spelling mistakes of tenants' names and also dated 2024, not 2025, is this likely to be disregarded? My understanding is that they are a little bit kind of flexible and a little bit understanding with these kind of typos. So I don't know, but as I say, not my area. So Will and Karis, is those kind of errors in the paperwork likely to be, is that likely to invalidate the eviction process, or is it something which the judge is probably going to say, yeah, we know who you're talking about, we know what date you're talking about, we'll continue?
Yeah, there's a history of court cases like this where you spell something wrong, or you make some error which on the face of it means that there's a full defense, because instead of claiming against Mr. Smith, yours claiming against Mr. Smoth or something, and there's no one called Mr. Smoth here. But the courts have said, and I'm sorry I haven't got the case to hand, but it comes up in notices and things. If it's possible to understand what they actually meant from that, and so if I said I'm doing a live stream tonight with Mike Hoden, everyone would know that I meant. I mean, there isn't another guy called Mike Hoden doing these, so um, everyone would know that it was Mike Hayden, and so no harm would be done from that. But the further you go down the road, so that if you said, if you gave, so it does happen where you give the wrong address and it's just a typo. But if you do, if the further you go down that road where it's difficult to identify what's going on, then the courts will dismiss it.
Okay, cool. So I think this person can probably expect that it's entirely plausible it will go through, and the spelling issues and stuff won't be enough to derail it. Cool. Next question. As always, guys, if you just joined us, feel free to like and share it and whatnot, just to help help the reach. That'd be cool. So number 5, when the council duties end, then what happens? Does this mean they can't help the person anymore? So um, I guess we'll have to work through the different duties that might apply. So we've got, my guess here is we're talking about the relief or the prevention duty. And as we've just kind of read out from the code of guidance for question 1, potentially, potentially councils can end the prevention and relief duty if 56 days have passed and they have kind of kept their end of the bargain, or they think they've kept their end of the bargain. So if the reasonable steps they said they were going to take as well, we'll help you try and find something, which if you think about it is very vague, doesn't really mean anything, doesn't commit to anything, and then 56 days pass and they can say, yeah, we've tried to help you, then yes, they can end the prevention and relief duties. Other duties like the main housing duty won't be ended until either you get evicted deliberately from the temporary accommodation, or you get given a suitable offer of accommodation, or you reject an offer of suitable accommodation. I mean, obviously, there's other duties kind of all kind of in the mix of all these things, but I think that's what we're probably talking about here. So it's not that they can't help. I mean, just to make the point, council can always help you. It's just they don't have to, and that generally means kind of that's kind of, you can guess what they're going to do then. So if you've approached the council, you've kind of triggered the prevention or relief duty, and the 56 days has passed, you may still be in exactly, you still may be homeless, but the council doesn't have to do anything, which might seem really stupid, and it is, but that's just the way the Homelessness Reduction Act works, which is very stupid. So, yeah, again, Will and Karis, you got anything to add to this question, or kind of think of any of the duties that might be worth covering here? Because as I say, there's lots of other duties. There's a duty to protect property. There's duties to give advice and assistance. There's probably some of the other duties as well, which I can't think of off the top of my head. But I think we're probably talking here about someone who's owed the prevention or relief duty.
Yeah, the only thing I would add is if the council says their duties have ended, don't necessarily accept that as gospel. If you're still homeless, then it may well be that the duty hasn't ended, but they're just saying it has, and that you could then represent or definitely get it looked at, because it's not, a situation isn't meant to come up. Like I was saying earlier, where they're saying, sorry, you're just going to have to sleep on the street. So, I mean, it may be that the duties ended for genuinely, if they say, sorry, the duties ended because we gave you somewhere to live and we don't owe you any further duties, and that would be okay. But if you're still in it, if you've still got a problem, then there's lots of other, as Mike, you said, there's lots of other statutory basis, because they, for help, getting help, like if you've got children, the duty will probably never end if you and your children, sorry, will never have ended if the children are facing homelessness, because there's duties under the Children Act, um, which are separate, but do include a duty to house.
Yeah.
So that's it.
Okay. Okay. Hopefully that's kind of that's answered the question there. Next question. Will, let me know when you kind of when you have an opinion about question 3. But yeah, as in like if you've kind of made sense of it. But meanwhile, we'll do this one here. No, not that one there. Come on, let's get the old copy and paste function working. Which is easier said than done sometimes. On this should do it. So here's part 1, and then part 2 is this bit here. So just to say, so I'm going to take this at face value that we have someone who's trying to help with their friends out. That's cool. There is an interesting local government and social care ombudsman case involving Herefordshire, which basically goes into a bit of detail about to what extent can you help someone else if you're not a professional. And if you go on Will Flack's website, then basically there's a LGSCO decision database. In fact, I can probably copy that into the live chat now. And if you just search for Herefordshire on that database, you'll get a bit of detail, because as I say, it might become relevant here. Because as I say, you can certainly help the person write their own letter. It might become a bit more difficult if you're actually going to challenge them on their behalf. As I say, it just becomes a bit problematic. But let me actually read the question. A friend was given a non-priority decision by his council. I've watched most of your videos about priority and how to challenge a non-priority decision, and I believe I can myself. legal aid solicitor and housing advice I've spoken to said unless I can get more evidence from healthcare professionals, it'd be difficult to challenge. Can anyone help with my letter? So I think if you've gone to a legal aid solicitor and they're looking at it and saying, yeah, we're going to need more than this, that would suggest to me that that's them saying, I don't think that there's enough here to successfully challenge it. It may also be because there's a legal aid solicitor who wants to get some juicy disrepair cases, which are worth more money than a priority need case. But in terms of can you help with it? Assuming you haven't taken up this legal aid solicitors, haven't signed up with them yet, then I guess you can approach other solicitors and see if you can get a more helpful solicitor. My guess that Will and Carousel is that they're at capacity. But yeah, but also on Will's website, there's a list of legal aid funded housing solicitors that you can approach. I think my impression of priority need is that even solicitors think that the threshold's higher than I think it really is. I don't think the threshold's terribly high. I think as soon as you've got someone with a significant condition of some kind which would be affected by homelessness, I think you're almost there already just on that, that's likely to deteriorate if you become homeless, which most things will. You're kind of already there already. I have a feeling that some solicitors, I don't know, they just haven't pushed hard enough in the past, and they've kind of got this malaise or whatever. They don't challenge this sort of thing. So just because this list has said that doesn't necessarily mean that I think it's a kind of dead case or anything like that. But in terms of other stuff we can do, I'm not quite sure if we have capacity to do anything else other than kind of just go over the videos and stuff and about priority need and see if you can see what your answer is. And if you can't get a solicitor to do it, then give it your best shot. There's nothing to lose by doing that. I appreciate if you lose, it's going to be bad for your friend, but it's better to try your best than not do anything at all. Also, if there is some more medical evidence, I guess, then go out and get it. Basically, if it's possible, then great. I guess it's not always. So, yeah, I think that's my answer to that one there. Will or Karish, you want to add anything to that?
Just briefly, I think that a legal aid solicitor saying if you, the client, can get more evidence from a healthcare professional, or unless you can get that, it'd be difficult to challenge. I think that's not good advice. Well, it may be good advice in the sense that it's true, but it's like taking your car to the garage and saying, unless you can get a mechanic, this isn't going to work. I mean, the solicitor should be getting the medical evidence. The solicitor should be advising you, so cards on the table. Either you haven't got, there's no way what you're describing could give rise to vulnerability, or yeah, it sounds like you've got vulnerable condition, and we should be getting medical. Now, a lot of solicitors are scared to do that because the costs are very high. Like you're off a GP. If you're talking about mental health problems, most GPs are scared of expressing views on mental health, or not scared. That's wrong word. They don't feel confident with mental health or making diagnoses, and they'll say, "Oh, you need a you need a healthcare professional, but not a GP." So what you need is a consultant psychiatrist. And obviously, a litigant in person can't go down to Harley Street and say, "Can anybody do me a report for which I can afford?" So you have the legal aid agency will actually pay the fees of consultants where it's necessary, and they'll do that under full certificates and under legal help. And what I'm talking about here is, fees of up to like £2,000 a shot. Because obviously, if it's a clincher, I mean, the solicitor who sends somebody to psychiatrists because they for some trivial condition which there isn't any basis for would be at risk of having those fees denied. But if, for instance, and it's very, very common, like post-traumatic stress disorder, for people that have, refugees are repeatedly being told, no, there's no evidence. But that's because they haven't been referred, and the GP doesn't really understand or feel confident with post-traumatic stress. But once you get them to a psychiatrist, they can spell it out for them, and then the council will back down. But so the answer to the question is do try. I mean, if you can't get a solicitor, then do get the medical records, which you can get for free, and just see if you can spot that the decision letter that you've got saying no priority need actually addresses those, because it's quite common that they won't have even bothered to get the records themselves, but they'll say something like, on the evidence you've given at your interview, we don't think you're in priority need. which is not the right test. Because if you told them you were really depressed, they'll say, well, no corroboration or something. So check that out. And I think maybe I'll try and do a video on how to challenge a non-priority decision, just the practical steps. But I would ask the solicitor to say, well, can you get me a report can you get a report from an expert witness? That's it.
Yeah. And there's a third part to the question, which is basically, no, not that one. Can one of us have a look over it? Now, I mean, I certainly don't have capacity. I don't think we'll all Karis do either. Like, I mean, we've both got day jobs and stuff, and both work long hours and stuff. So I'm afraid I think
Yeah.
this kind of live stream is as good as we can do,
The problem
unfortunately.
is we can't. I suppose that's the reason you warn people off asking for specific advice about their personal cases. But we as solicitors, we either have to, it's like being a doctor, you either have to get totally involved or not get involved at all. Because if I sort of help with a letter, I could be negligent if I haven't explored the person, well, if I haven't got the report myself. So if you can't really ask a solicitor just to sort of have a look at something, because their role as a solicitor is based on doing it properly.
I mean, and you saying that you might be able to find a local charity or something which kind of has some kind of degree of knowledge of this stuff. Now, unfortunately, most charities don't have a foggiest idea about this, but some do. So you might, CAB or something. That there's a chance that there will be someone there who knows what they're doing, and they can have a look over it. And they haven't got the same professional kind of ramifications of getting it wrong than a solicitor would. So I'm struggling to copy and paste the next question as well for some reason. It's another question about priority need by the look of it. So two adults were on the waiting list since 2017 due to low income. They've been asked to vacate the private rented accommodation by August. One adult was taking medication for depression and anemia. I guess the question here is, are they in priority need? There's a bit more to it somewhere. Hold on, I just saw it. Where's it gone? Oh, I'm sure I just saw something, but oh yeah, I think this is it here. Does this make sense? By the way, the GP asked the local authority to house them in 2 different occasions, but no help. What are the chances the local authority housing them? So the chances aren't good, let's be honest, just because priority need, because it's more complicated than whether you've got children or not. It's easier for councils to mess you around, basically. And also, GPs asking councils to house people has absolutely no weight at all. What GPs need to do is focus closely on what the person's conditions are, in this case, depression and anemia, and what is going to happen to them if they were to become homeless. Now, if it's significant depression, then that may well be enough. The council will almost certainly say that because there are two adults, I'm guessing we're talking here about households, so I'm guessing partners or something. The council will undoubtedly say, well, your spouse or your partner will be able to help you out with that if you're homeless. Now that may be a legitimate argument or not, but you can expect that. So your argument is not only to say my depression is likely to get worse if I was homeless, but you have to show that even with the support of your loved one or family member or whatever, that's still going to be the case. Councils can take into account support which is going to be consistently and reliably there. It gets a bit more spurious, I think, when they're saying, oh, you can go and get your prescription from a GP once a week or something. That's not really the same thing. But if you're likely to stay together, then they will treat you as a household. So yeah, I mean, again, look at the stuff on the channel. Look at if the fact the council said there was no help on 2 previous occasions. I also question. I think the GP at that point might be talking about stuff relevant to the housing register rather than the homeless application, because if the way I'm reading that is they haven't been homeless per se, although they might have been, but they haven't been recognised as homeless by the council for 8 years. They've just been on the housing register working their way up. And so actually the GP's evidence on the last occasions won't probably have any bearing at all on the priority need decision that would be relevant now. So part of the answer is make the application. There's videos on the channel. So there's a best way to make a homeless application. I'd follow that to the letter, which is laborious, but you want to do it, do it right. And there's a bunch of videos about vulnerability and priority need. I'd say the case you want to pay close attention to is Thomas v. Lambeth, because that involved a lady who's basically her diagnoses were depression and anxiety. And in that case, the judge said depression is a sliding scale. Just because you're not at the most severe end of the scale does not mean you may not be in priority needs. I'm paraphrasing. So have a look at that and have a look at the way that case was worded. So it's definitely worth a shot. The more evidence you can get from the GP, the better. But I would anticipate having to not only cross the threshold of vulnerability, but also have to do that with the fact that you have a family member who is presumably going to stay with you and be able to help out with some of those issues, which when that principle was kind of put into law in the Hotat case, one of the judges basically rebelled and said that's stupid, but that's what we've got right now. So yeah, and I don't know enough about anemia to know how that might be affected by homelessness. So I just don't know. So anemia may be another condition which could be very serious. I don't know enough about it. But again, you'd want to focus on what happens to you if you become homeless. What would happen if you became homeless? That's the argument, and that's what any doctor or any medic would need to focus on. It's no good doctor saying, you know, this couple's a lovely couple. Can you house them, please? The council just throw it in the bin. So I'm not sure if we can kind of be any more helpful than that, I'm afraid, tonight.
Sorry, can I just say,
Yeah, go for it.
Sorry. With anemia and your depression, you'd look at how it affects you in your everyday life and how this impacts you. And with anemia, you'd look at if there's anything else arises from this. So if you have to sleep for a long time, you get fatigued, and stuff like that. And I've been looking at this recently because it affects a certain demographic of women. And so looking at where it comes from, the root cause of that, is quite an interesting element. So look at what causes it and how it affects your daily life, is what I'd say.
Yep.
And the impact it would have on you.
Yep. Cool. Okay. Sorry, we can't be more helpful. I mean, the kind of the priority need and particularly vulnerability is probably, in my opinion, the biggest source of injustice within the housing law. So, but unfortunately, it's such a common thing. We just don't have capacity to be more helpful than we are being, really. So, yeah, certainly feel for people in that situation. And it's, as I say, it's an area where housing officers get away with murder, pretty much, metaphorically speaking. They do all sorts of outrageous things. So the next question, I think, relate back to this question up here. So, I'm going to put it back up here, but no, I'm going to put it back down here. I'm not sure they are related, directly related. No, not that one. Oh gosh, guys, I do know how to use a computer. It's just that whenever I select text in the chat, it just goes weird. Let's try that again. I don't think this is going to be it either. Nope. Yeah, we are. Yeah. So permitted occupant have no legal rights, but if their partner is a tenant and is evicted, what is the council's legal duty? Does council have to permitted occupant? No. Hold on a sec. There's more to it. Surely there's no argument. If a landlord is running you out of your home because she doesn't like someone who visits the home because of a relationship. So again, I first of all, this is not. I don't know much about this stuff anyway. I am not. I'm not quite sure if I'm following the question. Let's come back to that. Well, yeah, maybe Will and Karis can just digest that whilst I'm going to the next one. Thanks, Mumsy, for the feedback. That's helpful. Nice one. So sorry, guys, I'm scanning down to see what the next question is. Do you have any update on the renters reform? I don't. I have not been paying any attention to it at all because until it actually gets sort of like verified what it's going to be, I don't bother looking at it because there might be some tweaks and stuff that significant tweaks between now and then. So yeah, so once we get closer to actually being passed through and about to be kind of legislated, there will be I'm sure there'll be a warning. There'll be a period where we know what the law actually is before it gets enacted. So with the HRA, it was actually enacted in 2018, even though it was enacted in 2017. So there's time to actually kind of digest it all. So my guess is it's not going to be. I don't know. My guess is it won't actually be enforced until next year, but I might be wrong about that. There is a lot of political will behind it, so I don't know. Maybe it'll be rushed through. I don't know. So again, if we just ask people to rephrase questions so they're anonymized, they're like what if questions. So I'm just removing them there. Sorry for being annoying, but yeah, going to stick with that rule. So I think this is the next question here. Family received claim for possession from the court in London in April and no defence was made to the application. 2 months after this, still not receiving any possession order. How long does it take? I think this is where Will's going to basically say current experience is like many, many months. So like time period for eviction, Will, like we're talking like 6 months, 12 months. It's because the courts are basically knackered. So,
It's really difficult to say. Let's just see. Family received a claim from the court. No defence was made. So 2 months. So they haven't received a possession. So they haven't even got to possession order stage yet. So that's really difficult to say because if you'd said a possession order was made, there'd still be possible delays. So let's see. I mean, it's possible the claim has been dismissed and you just didn't get the order telling you it was dismissed because the landlord, the judge saw some error that you didn't raise. But let's assume that it's 2 months later. So let's assume that it was listed for a hearing, or if it could have been accelerated possession proceedings. So let's say a possession order is made. The big question mark is after a possession order is made, the landlord still has to ask the court to set an eviction date. Now, believe it or not, I've got cases where local authorities have spent months and they haven't sent a request off. And God knows why. I think it's because the solicitor needs somebody at the local authority to sort of sign off on it. And 6 months later, they haven't even sent off the application. And then, as you say, it can take. Let's assume that a possession order was made a month ago, and you're gonna receive the order sort of next month, and then the landlord is awake and asks for a warrant for possession to be issued. That would probably take about another month to issue. And then the eviction appointment is likely to be somewhere between 1 and 4 months after the notice you receive it. So if you work backwards from that, you've got that's 4 months maximum. I mean, let's be sort of worried. Let's call it 2 months for the eviction appointment, 1 month for the warrant to be issued, and 1 month. So you're probably looking at about 3 to 4 months if you sat back and did nothing now and you're just waiting for somebody to knock on the door and say we've come to evict you. You're probably looking at 3 to 4 months minimum. I hope that's helpful.
So I mean, obviously, don't know what's going on here, but this person certainly wants to be making a homeless application now if they haven't already, because the homeless application itself would be active at this point, and there would be potential stuff the council could help out with.
What I should add, sorry, is do contact the court, because if you've got the possession claim, then you can send if you Google the name of the court where it was, there's an email address, inquiries at whatever court it is, and send them an email with your name, with the case number in the heading and your name, and say I am the tenant. They may not believe you and say we need proof, but you could say, could you tell us, or ask the landlord. I mean, maybe you're scared that doing that will start the process I just mentioned, but it can't do any harm. You're best to sort of grasp the nettle and ask the court and the landlord what's going on, and then you can tell the council, because they're probably going to say to you, come back and tell us if you've got any news.
Yeah. Okay. Again, hopefully that's helpful. Although, yeah, it's obviously difficult to say or predict the future and stuff. Next question, which is a multi-parter. So hold on a minute. I think it's a bit more down here. So, model tenant receives to Section 21. Council is obviously trying to push her into the private rented sector. If she takes a private rented accommodation, the new rent will use up 90% of her pension. Can she take the flat but then still pursue social housing, the grounds of unaffordability? And what happens if she takes the private rented in a different council district? This person is clearly vulnerable, but no decision has been made yet about priority needs. Okay, so a couple of questions in there. So the legal answer to this is that council should not put anyone in any type of accommodation which is not affordable. However, we have a job because councils break the law all the time. But what you'd really want to be seeing that. So if you were to complain, so let's say they provided accommodation which was unaffordable, your complaint would be to see what their assessment of affordability was. They should have a document somewhere which has your income, what the rent is, all the things you need to spend money on. And basically from those calculations, the council should be able to rationally say we're satisfied this property is affordable. They probably won't be able to do that. I don't know a lot about pension, like benefits and pension stuff, but I guess there would potentially be additional benefits you could be applying for. I just don't know. I don't know how it all works. But as I say, the issue really here is the council's going to try or potentially going to try and put someone in unaffordable accommodation. So if it was me in that situation, I had a client in that situation, bearing in mind I'm not a solicitor, I would be complaining the moment they even kind of like there was a whisper of the offer being made where there has been no assessment of affordability, and I'd be kind of really on the housing officer's back to kind of work out what they're doing with all this stuff. As a general rule, and I'm sure there are exceptions to this, generally there is well, my experience is there's quite a lot of social housing for older people, like over 55s, over 60s, and so part of me says don't panic. I would say your chance of getting social housing might be higher than you realise. But I guess people in the situation would be rightly terrified if the council are going to try and put them somewhere which can't be, isn't going to be affordable. So, but yeah, I'm waffling slightly. The council need to give a rationale that is coherent, that says why that accommodation is affordable based on your current income or your potential income. So they might say you can claim universal credit, whatever it will be, pension credit or whatever it be. As well, and there's other benefits you could apply for to make it affordable. That's legit, but if they can't and they haven't had that kind of thought process yet, then it would definitely be challengeable. In terms of being housed in a different council district, again, it's kind of a question that the council, any accommodation the council give you has to be suitable. Part of that means it's got to be affordable. Part of it means it's got to be take into account your kind of care and support needs. So if you've got family who live in a particular area, for example, where there is a genuine relationship with them, then that's a big factor which the council would have to have a very good reason to try and push someone out of the borough for it. The council basically need to be able to say that they have tried their absolute best to find accommodation in the district, and if they can't, they'll get it as close as they can to the district. And it's surprising how many London councils are completely capable of finding accommodation in their own district. So while some councils will house you up in like North, Newcastle or something, that's just because they're probably acting perversely. It's not because they can't find accommodation closer. It's just because they're just trying to be difficult, probably. So that's that kind of element of the question. So again, the answer is the council have to be able to justify why a placement out of the district is suitable for that person. And then the third one about priority needs. There is no kind of age limit at which someone's in priority need automatically. So it's not like you hit your 65th birthday and you're now priority need. It doesn't work like that, but it is relevant. So old age obviously links in with other vulnerabilities. So, and again, the way the law works, the council don't really need to start assessing vulnerability until further down the process. That some people might disagree with that, but they don't have to make a decision about whether you're in priority need or not until the end of the relief period. You could argue that they might have to because this gets really convoluted. Another thing they'd have to consider when they made an offer of private rented accommodation is it'd have to be suitable, but it has to be a high level of suitability if you're in priority need. So technically, they should be making a decision earlier. If that went over your head, don't worry, because most housing officers don't understand that either. But that's probably what I'd say about that. So Will or Cash, you got anything to add to that? Because I did my best there, but I'm not sure how clear that was. But yeah, I think the short answer is get on the housing officer's case and just basically try and find out what their thinking is, and any kind of offer of accommodation, just basically immediately raise the fact that you don't think you can afford it. You might even want to preempt it and just say, look, I'm really worried that you're going to try and find me accommodation which I can't afford. What's your position on that? And that just a nice open question like that. It's not aggressive, but it will just get them to justify their position and also probably, hopefully kind of get them to think about it themselves. Hey, right, Michael. So in regards to question 6, someone has epilepsy. Yeah, I mean, so epilepsy, there is no condition, like there's no diagnosis, which means you're automatically in priority need. But epilepsy is probably one of the ones which come about as close as you can. But again, this makes it probably a lot easier. So if we go back to question 6 for a moment, because this is obviously a key issue. So, can anyone help with the tenant, right? So so your argument for priority need is not, you don't just say they have epilepsy, you say they have epilepsy, they have a tendency to have seizures, They need somewhere which is safe to live in all, and in order to manage that, along with any other treatments they're having, it may be they kind of qualify for other types of treatment from social care or the NHS. But and it often, again, I don't know a lot about epilepsy, but you want to research everything you can find out about epilepsy, because let's say, for example, it's linked to stress, and that being stressed is more likely to result in a seizure, then, and being homeless is likely to lead to stress. You have a very clear logical argument to say that this person has an existing issue, epilepsy. The kind of the consequences of the issue, as in seizures, as one of them, would likely be exacerbated by being homeless, and obviously that could involve harmful effects. That's kind of your argument. That's I've just kind of taken that from the Thomas v Lambeth case. So yeah, so I mean, and I would just run it. I think you've got a good chance. I mean, even that I've even seen housing officers training that they get, they'll note epilepsy as being something which is likely to result in someone being in priority needs. But again, there should be a lot of medical evidence for someone with epilepsy. There should be like lots of case notes, records, potentially medication that would you be able to get hold of to kind of bolster that case. But yeah, I think that's I think you've got, yeah, I'm a lot more kind of confident in a positive outcome there than I was before. So yeah. Okay, multi-part here. Question 11. So personal request is subject to access request from the council. So that's basically when you request a copy of all your records from the council, which is free to do. I highly recommend you do it whenever you're having a problem with the council. If a person sends a properly written complaint, including medical evidence, can it result in things like housing officer having to go through training again, an apology or compensation? It can result in all three of those things. Yep. So if you look at the LGSEO database, which is, as I say, on Will's channel, I'll put the link in the live chat a little while ago. The LGO basically they tend to recommend three things within pretty much every compensation case. One is an apology that's kind of meaningful. Secondly is a compensation claim, a compensation payout depending on what happened and how long it happened for. And then it's quite well, it's probably slightly less common, but the LGO will constantly or consistently or regularly basically recommend that the council undergo training about a particular issue. So let's say there was a failure around how someone with autism was treated, then it will be quite common for the LGSEO to say you put your staff on training around autism, that's something like that, or gatekeeping, or whatever it would be. So yeah, so that, yeah, I mean, I would, anyone making a complaint, I'd highly recommend reading through that database. In fact, let me just share the database to tell you what I'm actually talking about, because yeah, this is how I learned homelessness law. I'm a painter and decorator, but this is how I learned how to do it. And it was so if we go to the link here, so this is Will's website, WFLAC. So you've got here, this is no particular order, this is the order that they came in. So you've got this number here on the left is the basically the code that you want to copy and paste into the LGO decision database. So if there's a video on my YouTube channel which explains how to use it, it really isn't difficult. If you just go to lgo.org.uk and then search for decisions, you put that code into the decision box and up pops the full case. But what I've done here is I've basically included tags about different things councils tend to do wrong. So this one here, gatekeeping, burden of proof, perverse complaint handling. So there's probably about 100 different tags. You can look through the tags, see what kind of looks like it might be relevant to your situation, and then look at the full decision. You've also got the summary here of the case. So this one here, for example, involving Tower Hamlets, involved gatekeeping, assessment of disability and unsuitable temporary accommodation. If let me go a bit further down, because I've started to put in how much compensation people got, because that can be, again, quite helpful. So this one here, for example, Bristol City, unsuitable TA, disabled child, £2,100 compensation. You've got the summary there. But the LGO decision, the full decision, goes into a lot of detail about how they consider complaints, what the council should have done, what the law is. So as I say, it's a great way to kind of to learn stuff fairly quickly. So I'm hoping that, let's say someone has a situation where they're in unsuitable temporary accommodation, they could search for, if I go up to the top, the word unsuitable, Bearing in mind there's a whole bunch more cases to go on this in the near future. But you should then, has that worked? Yeah, I assume it has. You've then got that word unsuitable crops up in all of these cases, some of which result in some quite high compensation payouts. So things like damp and mold, that kind of stuff. But there's more, yeah, as I say, have a little dig around that site. Will's going to upload a bunch more on this weekend if he gets a chance. So yeah, right, time-wise, we are getting to the end of the hour, so no more questions from this point. If you've asked a question in the chat, we'll get to it. Let's type this in. And let's go back to the questions itself. Here we go. So yeah, good question though. So all yeah, good luck with it, basically. Right, so next question. Question 12. A council refuses to update a family banning on the housing register because the family asked for a review of homeless decision, prevention given instead of relief. The 3 weeks the council had to give a decision has passed and still no update. Complaint was made to the council, wrote to MP, but nothing happened. The family is missing out on properties because of wrong banding. Meet the criteria to have higher banding homelessness application plus another preference. So, okay, yeah. So basically, there's a bit more to it. Hold on. So this situation, I would complain. This situation it crops up regularly in LGSO decisions. And another thing that LGSO can do is they can basically ask the council, did your failure to give the person the right banding at the right time result in them losing out on properties? And if the council say, yeah, actually, this person would have been able to win bids during that period that we messed up, then they will be able to get a direct offer or they'll be able to kind of get put on the top of the list sort of thing. So definitely worth complaining about that. Yeah, fairly common thing. In terms of the complaint not being responded to yet, I'd go back to the MP first and say, hey, MP, can you chase the council, please? And I'd also probably contact your local councillors. Local councillors actually have more authority over the council than the MP does. The MP doesn't have any technically any authority at all, whereas councillors do. So that's my answer. Again, Will and Karis, feel free to add anything in. Hold on, lost my place. There's a question. So again, I'm not quite sure. I think this relates to another bit which I didn't understand, but let's put this in here because I cannot. So is it likely they'll separate family? Councils can't separate families. Even where they've got ridiculously large families, they still have to find accommodation for the whole family. So and there was even a case where the best the council could do is put a family in 2 different addresses next to each other, and that was found to not be good enough. So yeah, as I say, I'm not quite sure if that relates to another bit of question. So I apologise if that's not. Yeah, there's this question further up which I don't know if we can make sense of. So this one, number 8, I'm not following. Basically, this one here, and I think there's more stuff coming in about it, but I'm afraid I don't know. I don't know how to make sense of that. So question 14. Vulnerable person with health issues and struggles with paperwork who was in care and no family, are they protected person and can't evict, please? So if they've got a protected characteristic, which is basically any impairment which has a substantial impact on your day-to-day living activities, which would include things like being able to manage paperwork and stuff, and health issues obviously count as an impairment, then my understanding is it's not that a landlord can't evict you, it's that the landlord needs to have basically carefully considered your disabilities and carefully kind of done a lot of stuff. Will or Karis, do you want to give a bit more detail on that? Because again, I've only seen it from the outside. I don't quite know to what extent the landlord would need to comply with the Equality Act when evicting. I mean, but certainly I'd say there's no one with a disability, which means they can't be evicted. It just means it needs to be done properly. It needs to properly take into account their disabilities and properly give them the right support. So in this case, it might be that they need to find someone who can help the person out with their paperwork, something like that. That would be kind of necessary. And if that's not done, then potentially, the eviction would be thrown out, if that's the right word by the judge. So Will's nodding there, so I'm going to take that as mean that that's the answer. So yeah, a bit more detail about the pension the question about the person with pensions. They're £3 high. They're £3 over the limit to get pension credit threshold. So the same thing would still apply. So if there are no other benefits this person could apply to, where's it gone? Can't find the question now. Oh, this one here, 10. Then but the same situation still applies. The council still need to be able to positively show rationally that the property they're providing is going to be affordable. Okay. So I think is there more to this one? Hold on. I think there is a bit more to this one. If a council issues another non-priority decision for a reassessment of the individual's case with mental health conditions, depression, and dealing with domestic abuse, what are the next steps for the individual and their solicitor in order to overturn this decision? How long these steps are expected to take? So I'm going to take this to mean that there was an initial non-priority decision, which was then challenged through the Section 202 process, and that was not overturned. So, but the good news is that there is a solicitor involved here. But basically, the next steps are the solicitor would need to go to court, appeal to court under Section 204, which can take ages, and it becomes a bit problematic with getting someone accommodation whilst that's happening. But I mean, domestic abuse, usually domestic abuse is an automatic characteristic if you are homeless because of it directly. But then maybe you have someone who's got historic domestic abuse, for example, which would not kind of come within the automatic criteria, but it's certainly relevant. So again, someone with these kind of conditions is probably going to be in priority needs. Again, it's going to be helped by some clear medical evidence. But as Will said earlier, if a solicitor is involved, one of the things solicitor will be doing is basically getting expert witness statements or expert assessments or something, just to kind of give that level of detail that will be needed. So for me, again, not being a solicitor and kind of seeing this from the outside, the most important thing here will be whether the solicitor can get the person housed whilst the appeal goes to court, because it can take months and months. So that's my answer. Again, Will and Karis, feel free to chip in if you've got anything to add. I've just seen the time, so I want to keep things moving if we can. So next question. I was just going to check I haven't missed anything. Sorry, because I just jumped over some to get the second part of the question. So, question about whether the gas board can cap your gas without a court order. I don't know. That's probably outside of our remit here tonight. So I think the next one, that's a missed one. I think the next question is this one here. Again, guys, just for those asking questions, please just put these questions in advance in the week, because then we can then make sense of it much more easily. So yeah, just to do that, what you just go to any video on this channel, write the question in the comments, anonymize it, and I get a notification, which I then go on through on a Thursday sort of lunchtime and basically get the questions together. So it's just a much better way of doing it than just stick it in the live chat, because you're going to get better answers. You'll notice that the answers we gave to the first few questions were much better and much more organized than these ones here. 16, is it true that the income affects the homeless to be or not be housed by the authority? So yeah, I think we're talking here about affordability again. So yeah, just as I've said already, well, so are they talking about priority need here? So yeah, I don't know if that
may be talking about that you bit about, oh, you've got too much money, we don't have to house you.
Yeah, so I mean, so basically, yeah, let's answer that question, because if that's the question, then that's good. So yeah, so there's no kind of like amount of money. You could own £1 million house and be subject to domestic abuse, and the council will have a duty to house you. Now, it may be that you have millions of pounds in the bank, at which point you have to pay for the accommodation that the council provided for you if you're over the housing benefit kind of threshold. But yeah, so if that's the case, yeah, so there's no kind of like, as I say, a lot of councils say things like, oh, you've got too much money for us to help. That's not true. Or they might say, you've got an arson conviction, we can't help. That's not true either. It's just an absolute duty to everyone. But as I say, you'll be subject to paying the temporary accommodation cost potentially if you have a lot of money. So if that's the question we're getting at, then that's the answer. Section 83. So I don't know what anyone knows what Section 83 is, what act that's referring to. I don't think this is a housing question again. So yeah, yeah, okay, right. I think that's all the questions in the chat. That's before the point which I said no further questions. So if you put a question in the chat after I've said that, I'm afraid you'll have to. Your best bet is to copy and paste that question onto any video in the channel, and I will get it and I'll get it notified, and I'll definitely answer it next week. But for the time being, we'll now go back to the other questions that came in through the week that weren't anonymized, which are two. So 17 is this one here. I'm in supported accommodation. Staff are immoral and have harmed me, so I've stopped engaging with them to protect myself. I'm now being threatened with eviction because there is a clause in my tenancy that states I need to engage with support to stay. I've complained formally about their behaviour, which is being pushed under the rug as unsubstantiated. I have also asked supported living manager and local mental health team to write some evidence to state how being here is having a detrimental impact on my health in order to get increased banning on the council list, and they've refused. I wondered if you have any advice. So my advice is pretty miserable. If you watch the channel before, I detest supported accommodation as a concept. One of the many issues I have is that they have absolute power pretty much, and this sort of thing is very common. And unlike, we talk about challenging councils, there is a very good legal framework to challenge councils. It's not perfect, but it's there. There is no legal framework to challenge a supported accommodation provider, whether it be a charity or whether it be a CIC or registered company or whatever. And that power imbalance in that situation means that I have seen people in this situation and they'll just get evicted, and then they'll even get kind of found to be intentionally homeless because the council will then try and say, oh, you deliberately didn't engage with support. And that's probably not legitimate, but the council will probably do it anyway or try it. So any advice? If you can hack going to the, if you I guess either try and find a different support accommodation provider which is better and apply there and move there, or if you can stomach it, try and jump through the hoops they put. If it's not already a done deal, and just try and do your best. But in my experience of those kind of teams, once they see someone as being difficult, that's just the end of the road. They might take a few months to get rid of someone, but unfortunately, that's just what I've seen a lot, happen a lot. And it's a shame that the supported living manager and local mental health team didn't do anything. I mean, it depends, I guess, what you're asking them to write. If you're asking them to write that the supported accommodation staff are immoral, then they're not going to write that. But if you're asking them to write, has there been any kind of perceived impact on this person's mental health because of their living conditions, then that's probably a fairer question, and it would be disappointing if a supporting professional didn't answer it in writing. Certainly in Bedford, we're quite lucky. There would be professionals who would definitely answer that question helpfully. But unfortunately, I don't have any better suggestions for that really difficult situation. As I say, it's no good to this person, but avoid support accommodation if you can, is my advice. For many reasons, this being one of them. And then the final question for this week, which is quite a long one, but it does make sense, and it is kind of not, it's not overly long. So I'm the lady who lives in Council A but wants to move to Council B to help me. So this is a lady who's she's homeless, or she's going to be homeless. So June the 9th, I emailed a housing counsellor for Council B with my homeless application. It was past 56-day point of the Section 21 my landlord has served me. The councillor has not acknowledged my email at all, but I also filled in the council's generic online form attaching the same homeless application to it. I received the reference number for the form, but still no acknowledgement of my application. Is this usual? As of now, I'm not sure if anyone's seen it. If the council knows it exists, not sure if I should be panicking or just waiting to hear from them. I have a web chat with Shelter who arranged for Legal Aid to call me Tuesday the 10th. During this call, the lady spoke to said, just stay put until your landlord takes you to court. I'm unsure as what to do next. Do I rely on Council B helping me and wait until they acknowledge my application, or is there something else I need to be doing? If I get to the end of the Section 21 period and Council B deny me any help, is there any too late to notify Council A for the help, or should I just chill out and trust that not hearing from Council B is fine? I've done all I can. So, and should I get an appointment to chat to CAB? So yeah, chat to CAB. I think that the advice this person gave you to stay put until the landlord takes you to court is bad advice. I think there's some other things you could be doing at this point in time. Because you should have had an acknowledgement of the homeless application that you've made. You are owed the prevention duty, most likely, if I've read this right. If the section 21 was valid and it's within 56 days of expiring, which I think it already has, then you're at least owed the prevention duty, if not the relief duty. I would go back to the councillor in Council B and say, hey, it's me again. I made a homeless application to your council and they've not responded, and I'm going to be homeless soon. You have a legal duty to do something, and see what happens. Often what happens when you email councillors is they won't actually respond to it themselves, but there will be some emails being kind of happening in the background that you don't see happening. So I would initially go back to the councillor and say, hey, I want a response, please, from your council. And to answer this last question, if council B deny me any help, can I go to council A? Yes, you can. But if you want to be in council A, council B's area, then you want to just focus your efforts on getting council B to follow the law. Making simultaneous applications is possible, but it just makes it pragmatically, both councils will try and deny the duties. So yeah, it's better just to apply to one council at a time. But this person does have local connection, if I understand it correctly. So it's a sensible thing to do if they want to live there. But yeah, just get back onto the politely chase the councillor and say, can you get your council to respond, please? I believe I'm owed the prevention duty, if not the relief duty, and that will hopefully kind of result in a response. And just keep chasing it politely for the time being. So yeah, as I say, guys, for those who put questions after the cutoff point, put them onto any video on the channel, and I'll get a notification, and I'll bring them next week. Or try your luck next week by putting them into live stream, but there's no guarantee. And as we've seen, you won't get as good an answer because we don't have enough as much time to kind of unpick things and kind of prepare things from the code of guidance and stuff. So, but I'm hoping it's been useful. Yeah, take it easy, guys. And yeah,
Sorry, Mike.
you go.
I think I still have to go back to question 3 to answer it.
Okay.
So, which I'll do very quickly. If you remember, this was a case about a possession. I think this can be summarized as being a possession order has been made. Can I appeal it or set it aside? And the answer is I put a link to the shelter page in the chat there on Zoom, so you may need to post that.
Yeah, put it into the thing. Yeah.
But essentially, it's quite difficult to appeal decisions. But essentially you can do, but you've got 21 days to do it or longer if you can show a very good reason why you haven't. You'd have to show that the judge had made an error, which is difficult to do if the judge didn't have a defense in front of them and any other argument. So it's probably unlikely that you're going to be able to appeal that. You could apply to set it aside, which is different from appealing it, because appealing it's where you say the judge got it wrong. Setting it aside is where you say something went wrong in the system, so the judge didn't have a chance to consider it. And that would be, for instance, where you lacked, the defendant lacked mental capacity and so it couldn't take part. Or I had a case recently where a landlord told the client, okay, we'll tell the judge that we're not going ahead with this. No need for you to come to court. And then they went to court and said, can we have a possession order, please? So yeah, and so it would have to be something pretty strong like that. So I think it's pretty difficult to challenge that. But the shelter website gives you grounds, more detail on appealing it. So I hope that's a good answer to your question.
Cool. Yeah, I trust it does. Didn't make any sense to me because it's all jargon, but yeah, the way it is, isn't it?
That's me.
No. Just honestly,
No, I'm joking. No.
Every time someone talks about eviction process, I'm like, I'm lost again.
Yeah.
All right, guys. Yeah, see you next week. Will, do we think we're on for Monday on your channel?
I hope so. Yes. I've given my record so far. I won't commit.
Well, so I think what we're going to try and do, if Will has to duck out, then we'll do something on this channel, but it won't be answering questions. It'll be like the one we did on Monday, which was a bit more fun and a little less heavy. So yeah, but yeah, hopefully see you soon, guys. Take it easy.
Bye.